Case number 9 is a case about seizure and carpal tunnel syndrome, spondylosis, herniated nucleus pulposus. Magsaysay Mall Marine Incorporated and or Mall Ship Management Singapore Pte Limited versus Michael Paderes, Atraje, GR number 229192, July 23, 2018, 3rd Division per Justice Leonen. Facts. Atraje was hired February 11, 2014 as a seaman. On March 4, 2014 at noontime, he slipped and fell while holding a casserole containing water and sliced vegetables. His head hit the stainless disposer on the floor. He had a seizure and lost consciousness for about 5 hours. In a Singapore hospital, MRI, magnetic resonance imaging, EEG, electroencephalogram and CT scan, computed tomography scan tests were conducted on him. He was diagnosed with epileptic seizure with post-fit neurologic deficit, left-sided hemiparesis, or a weakness on one half of the body, from mild desiccation or tear at C3, C4, C4, C5, and C5, C6. These are parts of the cervical spinal cord, with impression of mild cervical spondylosis with multi-level disc disease. He was declared unfit for work. He was also diagnosed with herniated nucleus pulposus. Nucleus pulposus is a spongy material inside the bone of the vertebral column. So this usually herniates when the vertebral bone is fractured. There is herniated nucleus pulposus at L3, L4, L4, L5, and L5 to S1. With spondylosis and radiculopathy, as well as left carpal tunnel syndrome. He filed for disability compensation. Voluntary arbitration panel ruled in favor of Atraje. The Court of Appeals affirmed the VAP. The issue in this case is whether Atraje's disease is work-related and compensable. The Supreme Court ruled yes, per POEA SEC, Filipino Overseas Employment Administration Standard Employment Contract. Atraje's inability to perform his customary sea duties, coupled with the company-designated physician's abdication of their primary duty to declare his fitness or unfitness to work within the prescribed period of 120 to 240 days, transforms his disability to permanent and total by operation of law. What happened in this case was that the company-designated physician did not declare Atraje to be fit or unfit. So there was no medical conclusion on the side of the company-designated physician as to whether Atraje could continue working or not. Thus, by virtue of law, Atraje is declared to be permanently disabled. The Supreme Court explained that permanent total disability does not mean the state of absolute helplessness, but the inability to do substantially all material acts necessary to the prosecution of a gainful occupation without serious discomfort or pain, and without material injury or danger to life. In disability compensation, it is not the injury per se which is compensated, but the incapacity to work. The Supreme Court cited the case of Olidana v. Gibson's Maritime Incorporated, GR number 215313, promulgated October 21, 2015. The lesson we learned in this case is that seizure and nerve injury, if work-related, is compensable. We also learned that in epileptic seizure, which is a type of generalized seizure, there is unconsciousness, and it could be accompanied or followed by neurologic deficit. The unauthorized use or reproduction of this work will be prosecuted under the Intellectual Property Code and other laws.